the question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories, from First Republic to Fourth Republic, we have had a private members' bill such as this.
Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former...
In the very last Parliament.
The very last
yes, Parliament.
Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members' bill, and it was the first private members' bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the matter. I think it was not a very controversial subject matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the First Finance may assist the court in that regard. The first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. And especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern, because the basis for the Speaker to exercise or the person presiding to make a determination did not arise, because it was from the executive. But that is why I consider this point so important, that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president's status. So that's quite different. And if such a question has not been determined by the court, I think with all respect, the court has to be given an opportunity. And my preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made whichever way, then the nation can move on. Determine
which question? Determine the question in the substantive suit, or determine the question in this application?
No, Madam, determine the questions in the substantive suit.
The substantive suit.
So pending that, then there ought to be a preservation of the status quo for the court to be given an opportunity of determining. So this then also ties in with my examination of certain cases in which the Supreme Court has refused an injunction. And I'll first start with Wilford Kwaku against the Attorney General, reported in 2012, Volume 1, Supreme Court of Ghana report, at page 259. It is the Supreme Court, constituted by a single justice of the court, Justice Datiba, declined to grant an injunction. Because, respectfully, it was an action that related to a move to halt the creation of electoral districts under the Local Government Act. So, that was a peculiar case. There was the creation of electoral districts by the Electoral Commission, and indeed, the application was filed only or determined only in June 2012, 6 months before the election. It will have had an effect on the election, on after the election. The court in its wisdom actually stated, held at page 260, that in the interest of the public, the collective interest of the public, said that where the relief sought relates as here to a public law matter, particular care must be taken not to halt the action presumptively for the public good. The action was for the public good, and therefore the court declined it. But the second case occurred in the same 2012, That is runs for France. As for France, number 1, against the Electoral Commission and Attorney General, was filed in July, I think it was filed in August 2012 by my good self. And the court determined it in September 2012. The court would note, clearly, it involved the Electoral Commission. It sought to restrain the Electoral Commission from laying before Parliament regulations that had enacted for the conduct of the 2012 elections, 3 months before the elections. And for that matter, the court dismissed my application for an interlocutory injunction. I was not peeved at all. I moved on with my life. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have with all respect demonstrated before you, the collective good actually will be in respect of holding a status quo for the court to indeed determine whether the bill that is being sought to be, for want of better expression, rushed, is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament. Indeed, all the processes in Parliament have been completed. Parliament effectively has concluded the processes. And indeed, now, if what is supposed to be transmitted to the President will actually be titled an act, it is just to the signature of the President and then to become law. And I would say that, having regard to the completion of the processes in Parliament, what Parliament has done will constitute an act under Article 2, Clause 1, Paragraph B of the Constitution. That is an act, a small act, not the act with a capital A, Act of Parliament. It is an act with a small a, which is an action or a decision.
And so your presentation or your submission is that the jurisdiction of this court has been properly invoked?
Yes, as
for this application or for the substantive action?
Pardon me?
For this application or for the substantive action?
Oh, I'm only saying so because of the requirement in injunctions to show the existence of prima facie case as well as a substantial important question of law.
I think, can you clarify that point? I think I missed it. You are saying that Parliament has completed its processes, its procedures, and that what they are seeking to do is an act that's beyond its proceedings.
No,
is that what?
But I'm saying that now we can actually find an act having been committed, and the act has been committed. In fact, 2 acts. First is the opinion of the person presiding, which in itself will constitute an act. The determination by the person presiding will constitute an act by the person, not an act of Parliament. So once there is that act committed, it can be basis for the invocation of the court's original jurisdiction. Secondly, the completion of the processes in Parliament pursuant to the exercise of that discretion by the person presiding by Parliament will also constitute an act that can be brought within the premises of Article 2, Clause 1, Paragraph B. And indeed, I just want to have to emphasize that it's not an act of Parliament I'm referring to. It's an act as in a decision or a step by a person.
To help all of us, I think that I want to read 2(1)(a). A person who alleges that any act or omission of any person is inconsistent with. This is what you mean. Attorney General?
Yes, Mr. President.
Any act or omission.
Yes, Mr. President.
And your submission is that there is an act.
As in an action by a person, yes.
And there are 2 acts actually.
Yes.
This is your submission.
That's
the first act is the determination by the person presiding. And the second act is the completion of the proceedings.
Processes in Parliament. Respectfully, that's so. So I pray to rest my submissions, except as the court may have some questions. The court has no questions. May I rest?